for our week 12 webinar. Unfortunately, due to my crazy life, a judge let me know late last night that we have to jump back into a mediation at 9, so I'm going to pass off the hosting over to Jordy and Suzana just to do a few issues without me while I'm gone, but we're going to get as much done as we can in the first half hour. So good morning, Suzana.
Good morning, Ian. Good morning, Jordan, and good morning to everyone on the line.
Morning, guys.
So if we could just have everyone mute their video and their sound, please use the chat line. I'll monitor it as we go along, and so will the others when I step off. Okay, so what we'd like to start with today is working along our list of issues is executorship, and that is something that brings with it its own drafting issues, and it brings with it its own legal issues, substantive issues, and so forth. I want to talk a little bit about the clauses that we use, and I want to talk about the nature of the contentiousness that can arise. And one that, and also, what do we do if we don't have an alternate named? One of the scenarios that Suzana, you and I certainly run into often in a contentious world is a situation where you've got multiple executors, and they actually go so far as the issues arise so much so that we need separate representation for the executors themselves. Sounds a bit crazy. Should have one person running the estate or one group as one voice, and but there are situations like that. For an easy illustration, though, is that when you have a client who comes to see you and they have a corporate holding that, for example, that they have different. The deceased has a corporate holding, but that the children may have interest in it as well. The conflicts that can arise are numerous, and so sometimes it even gets to the point of requiring separate representation within the executorship itself. Another area where the conflict can arise is compensation. If the executors can't agree on how to split the compensation. So Suzana, maybe you could just comment on a couple of illustrations that you see where the problems arise, and then we'll call on Jordan to talk a little bit about the drafting issue when picking the executors.
Sure, Ian. When executors are appointed in a will, there's more than one, typically expected that they will act unanimously, unless there's a provision in the will that specifically says, for instance, that a majority rules situation can be relied upon. And so with that comes, of course, the possibility for conflict. And when there is that conflict and the need for separate representation, as you can imagine, it gets really expensive very quickly. And the expectation that those fees can ultimately be recovered from the estate goes down because of the fact that there is a multiplicity of counsel, and it doesn't make a lot of sense to the beneficiaries that there's need for more than one lawyer. And so that becomes an issue that definitely we see from time to time. Similarly, the fights over compensation, those can arise as well, because if there's more than one executor, the expectation again is that they be sharing the compensation probably equally. And when that's not the case, it does open it up to conflict.
So these are issues that we can create some drafting solutions to. One on the executorship for compensation is a very important one, because courts are reluctant to actually get into the muck and making decisions on that. You come to a court and you say to a judge, "Hi, we're here to adjudicate how we should split the compensation." You're going to get a resounding, "What are you doing here?" And in fact, there are not a lot of cases reported on it because of that reality. So there are some drafting issues that arise that we might be able to get ahead of it. The majority clauses, of course, can be a curse and can be an asset to a will drafting. A majority clause can, if you pick the wrong people in the majority, or if you pick the wrong people and there's a railroading of majority, that can cause tremendous stress in any administration. But a majority clause may be the only way to get things done. So, Jordy, from the drafting standpoint, what are some of the tools that you're considering when and this is usually an opening question in some respects. What are you going to do about the question of appointment of executors?
Thanks, Ian. So I'm just going to figure out if I can how to share my screen. Is that working? There you go. So I tried to come up with some help for. I mean, the selection of trustees is overlooked sometimes. It also, I think, depending on if you do it right or wrong, leads to more disputes than probably anything else, the selection of trustees, because putting power is where fights occur, and selecting the person who's going to have the power, and by implication, not selecting someone else and their perception that they don't have that power, really hits to the emotional core of disputes. And maybe it doesn't turn into a full-fledged piece of litigation and a removal application, all of that. But what it does do is lead to bad feelings and an emotional dynamic between the person or people who think they should have been appointed as executors and the person who actually was. So the selection of trustees, important to canvass, obviously, with the client. And here are some factors that I think should go into the decision making. So the idea of trustworthiness. Is this person by nature somebody that you have faith in to discharge this, and can they be trusted? Obviously, the very term trustee implies that. So that's probably the number one thing. The idea of common values. So if this executor is also going to be making discretionary decisions, whether it's how much to give to a beneficiary because there's discretionary payments allowed, or whether a property is going to be sold or kept, a trustee or an executor with common values is important. And because in a client's mind, they're trying to pick somebody who is going to be their placeholder if they're not here. So the age and health and willingness, those are all sort of together, in the sense that whether or not you decide to pick somebody, they can always obviously renounce and say, I don't want to do it. So the selection of somebody, the idea that they have to be willing to do it is important. Then the idea of age and health. So this all is contextual. That's why I'm always reluctant for sending out a client's sending out a request for a client's thoughts on an executor, and having them come back with somebody, because often they'll only pick the first one and not think about the context of the plan. So if we've got an immediately distributable estate that is going to last 2 years or 3 years max, well, then age is less important. If you've got a trust for the lifetime of a spouse or a child, or 40 years or 30 years or 20 years, then age and health all figure in there. So I'm always reluctant to get what the client thinks is the right choice without knowing what the plan is. I don't know if you or Suzana have anything to add with any of those first 4 items.
No, this is good. I mean, this is a good checklist, internal checklist that run by the client, and ultimately their personal decision. Suzana, did you have anything to add on that?
No, and I think it's just, as Jordy says, it's such an important decision. And we know that many times when people hesitate in creating a will in the first place, it's over the choice of a guardian, for instance, for their children. And I think also something that is difficult for clients to choose is the trustee. So those 2 appointments are particularly important, and having the opportunity to explain the role and to explain the importance of it, I think helps a lot in terms of choosing that right person.
I agree completely. I mean, when I'm typically discussing this issue with the client, and clients say, okay, what's the difference between an executor and a trustee and a guardian? And this is the way I put it. I say to them, look, there are three roles there, right? There's the executor, there's the trustee, and there's the guardian. The executor's job is administrative in many ways. Their job, collect all the assets, pay the debts, and then distribute the estate in accordance with the terms of the will. That is, either pay it out immediately to a person, to a beneficiary, if that's the way their gift is structured, or pay it over to the trustee for anybody whose inheritance is held in a trust. At that point, the trustee's role begins, and their role may be more discretionary. It may be managing that money, investing that money, and making decisions about how money is going to flow out if there's unlimited discretion. And then the third role is the guardian, and I'll just describe that as a surrogate parent role. And they're going to be making decisions about, healthcare and education and religion, and the things that parents make decisions on. And those three roles can be filled by three different people or the same person. But that's the way I describe the distinction, especially between the executor role and the trustee role.
Sorry,
yep.
Go ahead.
Sure, no, please jump in. Yeah.
No, I was just going to say that, can you just talk a little bit about the unique appointments where you say that those are three roles? For example, literary executors.
Right. So you can have different people doing different parts of the administration. The classic one was this idea that you had, if you have a special asset that requires very special expertise, for example, you have what was historically called a literary executor. That was an executor who was going to deal with your literary works and your copyright and publishing and those kinds of things. We see that with art. Somebody who's an artist, and you need somebody very specialized to deal with the appointment of an executor, just to deal with those assets because they have the special expertise to deal with it. Another example is for lawyers. So if you're named, for example, I'm named in a few wills as an executor. If I start acting in that role and I'm the last name executor, I start acting and I die, my executor is going to take that role over, be required to take that role over. Now, I may not want the same person who's dealing with my family as the executor to also have to run another estate that I was halfway through. And so there's another example of where, a lawyer or anyone who has a trusteeship or an executorship of someone else, you may want to have a special executor to take over those roles. And so those are some examples of specialized executors.
And one that's particularly timely these days is the appointment of a digital executor, someone who can administer your digital assets. And as we look through the list that Jordy has here of selecting trustees and the qualifications there, it could be that a person who is generally suited for everything else in the administration may not be the same person who can deal with digital assets. And so we've seen a lot of situations where a separate appointment is made for that role as well.
Yeah, it's a great point. And maybe we'll talk a little bit about digital assets. I mean, it's interesting, you're often giving the executor the authority to deal with digital assets the same way that you add. Now, there may be things on there that you don't want people to see. And so I've seen that before where they say, I actually don't want my executor to share all my information with my family. And so sometimes we're a little cavalier with that stuff. And we're all trying to come up with, we've been talking about this for 10 years probably about how to deal with digital assets. I don't know if there's certainly no perfect way, but there are complications there, and dealing with the choice of executors that you might not want sensitive data going to, other people.
So Jordy, on that example where you had an executor who said that, that's obviously something you could see occurring. What did you do?
So what we did was we indicated that in this case, it was an executor to turn over all digital assets to this other person who was to determine whether, if any of it should be disclosed.
Well, that's fascinating.
Destroyed.
All right. Well, some of the other headings here, of course, are pretty self-evident in its own right under your slide, which is really helpful. I guess the last one I just wanted to talk about was financial management ability, because that one is often used and abused a little bit on the choice of appointment. Maybe we could start with Suzana, your thoughts on the importance or the disproportionate importance of choosing on the basis of financial management, and some of the tensions that have occurred in the contentious side, and then Jordy, how you're approaching it on the solicitor side.
Sure, I think it is an important consideration for many estates, and particularly if you've got some complicated assets. It is a discussion that we want to have with our clients to make sure that we've got someone who can understand the breadth and the nature of the assets and might be able to better administer them than someone who doesn't have that financial capability. But by the same token, there are many opportunities for individuals to get advice as executors, and they can then have someone assist them with it. At the end of the day, of course, it becomes a question as to the cost of that and whether or not that was reasonable. But it is certainly a consideration, an important one in certain estates, I think, and something that we want to explore given the nature of the assets and the actual administration plan.
Jordy, do you have any comments on that part of it?
I put it at the bottom for a reason. You can hire the people who you need to manage to provide financial advice. So I put that at the very bottom. But the one, I do want to mention one other one that we sometimes overlook, and that's this, I put it down as relationship with the beneficiary, but I mean more than that. So, very often somebody will say, well, I'm going to appoint, my brother, he's very, very close with my son to be the trustee for my son's money. And I say, well, that's okay. That's good. Trustworthiness, common value, willingness, competence, experience, etc. Think about the dynamic, though. I say to the client about that relationship. So right now it's close uncle and nephew, and that's a wonderful, loving relationship, and that's fabulous. Now you're introducing somewhat of a business relationship on top of that, and not only a business relationship, but one with where the uncle is going to have to potentially say no to the nephew and say, no, you're not doing this, or yes, you are doing this, or can I have more money, please? And it changes that dynamic. It changes that dynamic. And so I'm not saying that that's the wrong choice. The problem with selecting a trustee is if it was as easy as a checklist, then we'd have no problem. It's for every solution here, for every yes, there's a corresponding issue that's raised. And I think that people sometimes don't put enough emphasis on that issue. And the idea that, this is going to change that dynamic. That dynamic, the relationship with the beneficiary, the dynamic that's there, how is that going to affect your choice? Same in putting one kid in charge of another kid's money. That's a rule I try to enforce with my clients and say, don't put one kid in charge of another kid's money, except in extraordinary circumstances because of the dynamic that's created. And if clients are thinking about how do I avoid, people always say to me, I don't want there to be any fights. I'm going to put this kid in charge of this kid's money. I'm like, well, this is why you don't do heart surgery on yourself. Like, right? I mean, I love when clients say that to me. I don't want to cause any problems, but this is what I want to do. And I'm like, okay. So
at that point,
I think that's something we should discuss and with our clients. And the last point I want to make on this really is I'm a believer that an independent trustee in many cases would eradicate any bad feelings and among beneficiaries and avoid litigation and contentious matters, because there's nothing that brings people together like a common enemy. And appointing, a third party who everybody agrees is so slow and so, can you believe they're doing this? And can you believe they're doing that? And all of that stuff brings actually people who would be, if you would put one of those people in charge, they would have caused a war. And here we have somebody independent. I truly believe that. Yes, it costs money, but man, that's money well spent in some cases.
Suzana, can you just comment on the point of trust companies' roles and also on the pricing if you get it organized in advance?
Sure. If you do, in fact, reach out to these individuals and try to line it up in advance, I've seen many instances where you can get a very favorable arrangement that makes a lot of sense. And so the expectation or the belief that trust companies are more expensive doesn't need to be the case. And in fact, they could be less expensive depending on the nature and the extent of the assets. So making those inquiries and getting some thoughts on that, I think, is really important, because to Jordan's earlier point about the relationship with the beneficiary and the importance of, the family dynamic, and that one of the things we want to keep in mind is that once you do choose a trustee and you name that individual, it's going to be very difficult for the beneficiaries at the end of the day to try to remove that trustee unless there's clear evidence that they're mismanaging the estate or acting improperly. So notwithstanding the fact that the uncle and the nephew, their relationship is changed, or that the siblings are not happy with one another's work as trustees, it is a very high threshold that the court is going to apply before they will remove a trustee. So making that choice is a really important one, and it's just one of the other things that we're adding to our checklist in terms of the importance of these kinds of discussions with our clients.
So one of the things too, go ahead, Jordy, did you want to add?
If I'm going to push a independent trustee or recommend it, I often say, look, trust companies are going to be less expensive than if you hired me. Like if you appoint me as an executor, I'm going to charge the most I possibly can. And so I'm going to seek, 5%, whereas trust companies will charge, will discount because they want the work, and they want to get the financial management and the assets under their control. And so, I think to some degree, trust companies get a bad rap because they're, seen as expensive, but in reality, they're cheaper than they're more expensive than if you get somebody who will do it for free. As I always say to people, if you got somebody who will do it for free, yeah, you're paying too much. But be careful if somebody's going to do it for free. So,
I just want to canvass your thoughts on this. We've talked about it in the context of executorship. Can we talk about it in the context of appointing trust companies with powers of attorney, and maybe comment on both powers of attorney, trust companies' roles with powers of attorney for property and powers of attorney for personal care? This is a question that's come in, and it's a good one. Maybe Suzana, do you want to start?
Sure. In my experience, I've only seen trust companies appointed as attorneys for property, and so they will help manage estates or the assets of an individual while they're alive. I haven't seen trust companies willing to jump into the role of personal care attorneys. And so I don't know, Jordy, if your experience is different on that.
No, they won't. And that is probably the last thing. I'd rather have the PGT Act than a trust company. No, they wouldn't take that role. I agree with you, Suzanne, completely.
Okay. All right. So, Jordy, did you have anything else you wanted to add, or Suzana, in terms of the choice of trustees at this point?
So just on the power of attorney, sometimes, when we're going through that discussion with clients, I typically start with, okay, who have you thought of for executorship? But the role is different. Because that's going to be especially if you've got an ongoing administration of power as an attorney for property that could last for many years and is more intense. It can be, day to day kind of a role, and which an executorship might not be if it's an immediately distributable estate and that kind of thing. So, and again, you're alive. So, it's maybe more important to you who you're picking as an attorney for property than once you're gone. So, you know, that, and it's an onerous job. Anybody who's acted as an attorney for property, it's an onerous job in many ways, and with the same kind of obligations, and in a sense, even more. So.
All right.
And sorry, and I was going to simply say that, and I also find that it's surprising that most people who are appointed as executors under a will know to go and speak to a lawyer, and then they go and they get their advice on how to administer an estate. In many cases where people are appointed as attorneys for property, I don't find that they will take that same initiative to go to a lawyer, seek advice on their responsibilities and duties. And that just makes it much more difficult for those individuals to carry out their roles. And then at the end of the day, when people are holding them accountable, to know what was actually expected. Because you're doing good for goodness sakes, right? And no good deed ultimately goes unpunished. So it's important that people know that it is a very important role and that advice should be sought, because there are requirements and expectations that you wouldn't necessarily think about. And the other thing I was going to add is the importance, sure, of choosing your initial executor and choosing your initial attorney for property or personal care, but you also have to give a lot of thought to alternates, people who will step into the situation or that role if the individual who's named either decides they don't want to accept that responsibility, or they can no longer assume that responsibility. And that is hard enough to choose someone initially for that first role, but secondly, to have someone as a backup, I think, is equally important and something that we want to give thought to as well.
Ian, I think you have to get going.
Yeah, no, that's great. So I'm going to thank you. I appreciate it. I was just going to actually do a little segue here. There's been a good comment on the chat line about the experience of one of the users saying that one of the participants telling us that trust companies simply will not act as personal care attorneys, and that's all of our experience as well, and often won't act as attorney for property unless it's the right circumstances, and typically want to have do it on a dual role. So that's helpful. All right, so look, I'm going to have to jump off, but the next area that we were going to try to canvas, I'll just throw it out at you guys, and you guys take it as long as you need to. Once we hit the half-hour mark, it's over to you. But I was going to just have you, and maybe Suzana could start with talking a little bit about failed gifts and the rule in Saunders and Voce and what happens with failed gifts. And Jordy, maybe you could talk a little bit about the mistakes in drafting with lack of provision for gift overs or failed gifts. And we were also going to talk about spousal trusts, but you guys take it as far as you need to. I'm going to jump off, and next week we're going to dive into insurance policies, designations, and drafting in that regard. So we'll start off with that the following week. But I'd like you, if you want to cover those issues, and otherwise, sorry to jump off on this. Everyone have a great weekend and enjoy.
Thank you, Ian.
Suzana, now that he's gone, all that stuff.
That's right. Now we take it over.
Before we get to any of that, I mean, forget me. You know, like, he won't know. I want to stay on the power of attorney issue a little bit longer, just about the dynamic between, excuse me, the personal care attorney and the property attorney, and how decisions are made between that. And just to lead off is the idea that our legislation talks about the obligation of the property attorney to follow the direction of the personal care attorney to the extent that there's money available. And so what kind of disputes have you seen many disputes there where the attorney for personal care different than the property one, and your views on that? And I'll try to pull up while you're talking about I'll pull up the legislation just to show people that.
Sure, Jordy. The easiest illustration is a situation where, let's say, two children, one is the property attorney for property, and another child is the attorney for personal care. And the personal care attorney wants to put mom or dad into a particular facility if they can no longer live independently. And you can just imagine how the situation can arise where there's a choice of a particular facility that is less expensive than another facility, and a concern over, firstly, of course, the ability of that incapable person to fund those expenses going forward, but then the nefarious concern that perhaps at the end of the day, we're eating into an estate that we're ultimately going to be beneficiaries of a lot faster than if we had put mom or dad into a less expensive home and incurred less expenses. So unfortunately, as disgusting as that situation sounds, we see it a lot. And I think that's why we've got the legislation that gives us some guidance on how to deal with these kinds of situations.
I'm just going to do a search here for the legislation. The good thing about powers of attorney is that we have a codified set of rules about what attorneys can spend money on. And so the good thing is that it's sort of set out. And it does say that you know, the attorney for property shall spend the money on the incapable's education, support, care, and their dependents. So that's, you know, often clients are concerned, you know, this is all fine and good. My kids are going to be looked after if I die because I've got these trusts for them. But what happens if I'm incapable? And that's a very important point. So first point to make about that is the duty of the attorney for property is not only to the incapable person, but to their dependents as well. And the dependents are, you know, are the typical idea of dependents, that is spouse, children, etc. So that's right in our legislation. So in dealing with clients' concerns about that, I say, look, there is that obligation. And letters and notes and things like that are going to be helpful for the attorney, because imagine that, you know, unlike a trustee for a child where the parent is deceased, it's clear that this money is for that person's benefit, and there won't be that much concern about what's spent. But in a case where you've got the parent living and their needs being looked after and the child being around, does give rise to conflicts. And so, you know, I think that's important. The key here is that the legislation, I'm just going to pull it up. Sorry, I'm talking and I'm going to try to figure out how to share my screen here. If you just give me a moment and I will pull up. There we go. This is the section about expenditures in section 37. So it says, look, you got to pay expenditures that are reasonably necessary for the incapable person, but also for the person's dependents. But first is the incapable persons. So when looking at priority and those kinds of things, we first have to take care of the incapable person and then their dependents. And so, you know, that's, hopefully they have enough money to deal with that, but that is the way our legislation is written. And then I guess it makes sense, except that those dependents need the money as, you know, often just as badly as the incapable person.
And you see right below that the reference to the guiding principles, which I think is very helpful as well, because it helps with these kinds of decision-making thoughts that have to be implemented when you're dealing with competing claims against a limited pool of assets.
Right. And when drafting powers of attorney, you know, it's another issue. In the next section is the idea of, just because we're on the drafting of POAs a little bit, is the idea of gifts and, you know, the ability of the attorney to gift money. So if you've got an incapable person, an elderly person, let's say, and their needs are not, there's enough money in their estate with their property that they won't need it all during their lifetime. There may be some reasons why charitable gifting, gifts to family and friends, might be a good idea. And so there's all these rules about that, but the power of attorney can also itself, the document itself can inform these as well. And so that's just another area to talk to clients about, is this idea of, you know, gifting and those kinds of things. And there's provisions basically to limit that. So just wanted to talk about that for a second.
And that's a good point, Jordy, because from a litigation perspective, we see a lot of fights over those kinds of steps being taken by attorneys to gift or to loan money to individuals. And I mentioned earlier the importance of seeking legal advice when you're in this role, because you wouldn't necessarily know, and you wouldn't expect it to, you know, possibly be offside. And if it is, you'd want to know in advance so that you can make these decisions in an informed fashion, rather than being held accountable for them at the end of the day when someone forces you to pass your accounts and explain why these kinds of gifts or transactions were incurred.
So this is just to that point. These are sort of either or type clauses in a power of attorney that we use, and it's a recognition and to protect the attorney, right? So, you know, for somebody who has enough money, the idea that the attorney can make gifts and loans to relatives and friends and charitable gifts, subject to the SDA, and then some sort of protection. So it's a matter of judgment, and it's my wish that the decisions of my attorneys be accepted because I have confidence in them. You know, in other words, we're going to start with the presumption that they're doing the right thing. And that's going to give them some place, you know, that's going to give those attorneys a place to or some protection from that kind of thing. The other, the other kind of option, but is to say you're not to make any gifts or loans or gifts in this case to anybody else. And so, or you can just leave both of them out, which is, you know, probably majority of my powers of attorney have neither of those two clauses in, because the client doesn't know. I don't know if I ever want them to make gifts, and I don't know if I want to stop them from making gifts. So we'll just leave it to the SDA to apply and to the discretion of the attorney. But in situations where the client has great charitable desires or and sufficient money and things like that, that paragraph E might be a good indication. So, that's really all I want to talk about on the SDA stuff. So, now what did? Oh yes, Ian and the. We're definitely going to not do what he wanted. So I just wanted to get to. I want to get to the idea, since we talked about trustees, the idea of replacement of trustees, because for the life of me, and I've given speeches on this topic. I've written on this topic. I'm still not sure about it when anybody asks me about, can we replace this person or not? So the Trustee Act has a provision about replacement of trustees, but it requires more than two and talks about the personal representative taking over for the last one and things like that. Suzanne, do you have any comments on replacement when we're about trustees and executors?
Yeah, and I think there is a difference between the replacement of executors and the replacement of trustees. And the Trustee Act specifically speaks about trustees, and there's a carve out of some sort for executors. And so what I normally see is that there is a will that appoints, let's say, an executor and an alternate executor. If the named executor, his role or her role comes to an end, or they've not accepted at all, the alternate trustee would take on the executorship of the estate. And if he or she were to pass away before they had finished the administration, as you alluded to earlier, Jordy, their executor in their will would take on that role if they had actually probated the will. And so there's that devolution of executorship if the will has initially been probated, and if not, then you're looking to how you can appoint another executor by virtue of a court order. Whereas with a trustee situation, you're pointing to the retirement of trustees and the power to appoint new trustees, and it's exactly what you said. The last of several named trustees can appoint a successor trustee, and just trying to look at your provisions here. So it's a little different.
Yeah, so there's the retirement. The problem is that it talks about where there's more than 2 trustees, somebody can retire. This is all subject, all of this legislation is subject to the document, to the trust or the will in the case of a testamentary trust. And so, it's very complicated. Well, it's to be honest with you, it's from the mid 1800s. And it's got old language, and it's not that helpful. There is the power to appoint through a will and things like that. Again, I just prefer to deal with the provisions in the will itself. And so I'm just going to try to pull up. I don't know if you guys can see this, but sorry, I'm just going to. So I would typically put in a replacement provision for the to allow a trustee appointer. So if I've got, whether it's 1 trustee, 2 trustees, or more than 2 trustees, I don't want to rely on that provision of the act to say when somebody can resign and when they can't resign. So what I just typically build in is this idea that if I'm down to the last trustee, and they can appoint a replacement if they don't want to do it anymore, or if they die and they haven't named a replacement, that their executor can name a replacement, et cetera. And so that we don't end up with a court application unless we're down to the last situation where there's literally nobody's done anything. And so I think it's I never used to have a replacement of trustees provision in here, but it is helpful, and it's obviously subject to any specific provision. So it doesn't say automatically that named trustee can appoint a replacement. It says, okay, if I run out of trustees, and there are certain circumstances where you wouldn't want that, I presume, but that's the idea, and they can then appoint, and that's kind of not an unusual circumstance for inter vivos trusts, but I think it makes some sense with respect to a will as well.
Absolutely.
So
otherwise, the alternative is a court application, and that just becomes, expensive, cumbersome, and potentially even litigious.
Exactly, and it's just and then there and not only that, the delay, the gap between a new trustee and an old trustee, and then you've got stub periods that you have to account for, and yes, there's a survivorship provision that says the personal representative of the last acting trustee can, but do you want that burden? So that's so that's not a bad idea to have something in your will when you're appointing trustees to allow them to figure out a way, if they're the last one, to get a replacement in there.
Absolutely.
So there we go. There was, I think, a question about contributions. The contributions of an attorney for property making contributions to a TFSA and an RSP, where they're named beneficiaries who are likely benefit from the contribution. Do you have any comments on that, Suzana?
No, I'll let you start on that one, Jordy.
Okay, no problem. So this does arise occasionally, not only in this contribution, but you can see the conflict there. An attorney for property can't make a will, but what they're in effect doing is changing the disposition by adding more money to one account where there's a named beneficiary. That beneficiary is going to get more money, rather than if they didn't make that contribution, would be in the residue, and the residuary beneficiaries would end up getting more money. And so that's the conflict. And so you can build through that. You can build that into the power of attorney if you see it as a problem. I'd be concerned, to be honest with you, about doing that. The way to do that might be just to simply create a new if you're doing it for tax purposes, just create a new RSP if you want, and do that without a beneficiary designation, and then you're not changing the disposition, as it were. I think there is a risk. I think if an attorney said this to me, I'd say, I don't like that. Let's either get directions from the court before we start doing that. Where you see a bigger problem is, and I've had this personal experience, the client has assets that have designated beneficiaries already, or their joint assets or whatever. And depending on where the payment of expenses is coming from, you're going to affect different beneficiaries. And so, you know, how do you do it? Do you do pro rata? Do you do it equally? Do you take into account tax implications? That's something that we don't typically have to worry about as an executor, but as an attorney, that is a key issue. And so if the incapable person has an RSP that they could draw on and a bank account, you know, and the RSP has a beneficiary designation, the bank account doesn't, but they have to take money out, and like that is a conflict. And that's exactly why we have the provision that allows a court to give direction. So do you?
I agree, Jody, and that's an important one, because when you're in these situations and you're just not sure what the right answer is, you know, by virtue of the Trustee Act, we can go and get some advice on how to administer in those circumstances, because otherwise you can imagine you're just going to be held responsible by one or the other beneficiaries who are disappointed as a result of what's ultimately left at the end of the day by virtue of those decisions having been made.
Yeah, and I mean, that's why being an attorney is in some ways way more difficult than being an executor, because of this. You also don't know how long the person's going to live, and so all of these decisions, you know, could backfire on it. And so it's a really, you know, in a state, you know pretty much when it's going to end, or a trust, you know when it's going to end, but for this you don't, and it's not easy to plan, and so that role is a difficult one. So I agree with you completely. I say we wrap up.
All righty. I don't think we have any more questions. If anyone does, they could just quickly add it. Otherwise, we'll, in the interest of time, definitely wrap it up and thank everyone for participating. Feel free to send us questions for the purposes of next week's webinar if you would like. And did we get a question there, Jody?
Yeah, we got a couple of questions. Could you comment on the rights of beneficiary to monitor the actions of an estate trustee? I'll throw that one over to you if you're, so there, I guess, talking about the idea of passing of accounts and monitor the actions. Yeah.
And I always say that to my clients, is that when they're beneficiaries of either trusts or estates, that at the end of the day, the executor or the attorney is going to have a duty to account. And so when they have concerns about steps that are being taken or about the individual who's appointed, there is this accountability process that at the end of the day gives you some comfort, because you get to see how the estate or the trust was ultimately administered by virtue of a passing of accounts. And that is the way that the system is set up, so that we hold fiduciaries accountable and we have opportunities to ask questions about transactions that were made or to seek explanations as to why things were done. And at the end of the day, it's also the means by which a trustee or an attorney can get a release from the estate or the trust in the event that they can't get it from the beneficiaries themselves.
Right. And I mean, when I start acting for estate trustees, I say to them, look, you work for the beneficiaries, so you better keep them informed. I mean, that doesn't mean that they get to run roughshod over you, but you have an obligation to keep them informed. Not every day, but you know, that's for sure.
Absolutely. And you mentioned at the beginning, it's all about the power, right? The power of that role. And many times we'll see arrogant executors or arrogant attorneys who take on the powerfulness of it unnecessarily and won't be transparent and won't be sharing information with the beneficiaries just out of whatever reason they choose to be that way. But I find that that's the most dangerous way to administer an estate or a trust, because you just create distrust in the beneficiaries, and it just makes it more and more difficult at the end to explain or to justify what you did if it wasn't necessarily done properly and with their informed consent.
Great. And the last question is the idea of what to do when you're acting as an attorney for property and the incapable person turns 71. The magic there is the issue about a RIF, RSP converting to a RIF. And it's troublesome in the sense that the beneficiary designation may not carry of the RSP may not carry over to the RIF, and because it's a new plan, And there's some, there is some, that's wording that you could put into your power of attorney, for example, to say, I do allow my attorney to, confirm the designation of any a RIF that is converted from an RSP. Whether or not that's allowed is a whole different story. Many of the financial institutions are hesitant or concerned about that because that is seen as akin to making a will. And that's not allowed under the SDA. Even if your power of attorney says you can make my will, you can't. So I haven't had any personal experience with that, but it is an issue. And that's another place where directions of the court might be necessary to protect the attorney, because that could result in a huge disappointment to the beneficiary of the RSP, who's now not a beneficiary of the RIF, simply because of a conversion to a RIF. So it's a very important practice point, and but I don't have any personal experience, and they're asking for that. So so I think maybe that's anything else that you want to say, Suzana? Before we...
Nope. And I think we're ready to wrap up now.
I don't know about you, but I thought it went really way better without Ian here, but that's just me. Thanks to everybody, and hopefully we'll see you again next week. And have a good week and a safe week, and we'll see you soon. Thanks, everybody.
Be safe, everyone. Bye-bye now.